We do bring in. Today we're going to discuss about the travel ban lifted starting from November 9th. We're going to discuss about the Senate budget reconciliation and the immigration aspects of it. We're going to also discuss about how to prevent the wastage of the employment-based green cards. We have lost 80,000 green cards and we don't want to waste any more green cards this year. So we are going to try to guide you so that we all can be in a progressive, in a way where we make sure that no green cards are wasted. We're going to also discuss about, what is Congress feeling about family immigration and what do they feel about the employment-based immigration. Emily, on the travel ban, what's going on the travel ban though?
So we did finally get official announcement from the president lifting the travel ban effective November 8th for those travelers that are fully vaccinated. There's an exception for kids who it's not safe to go through vaccination, and so they have testing requirements within a certain number of days of travel. But that's definitely welcome news, since many people have not been able to travel for quite some time, and we've been having, to get the visa, you have to have this NIE letter from your company or qualify under all these different exceptions. So all of that should be going away November 8th. However, that doesn't mean the visa situation is going to immediately improve, because consulates are still not operating fully. They're still only limiting appointments for emergencies right now. Some of them are still closed. So we'll have to take some time before consulates are back open and offering visa appointments like they used to pre-COVID.
And before you go to your home country, you better have an appointment there. Don't expect that you go in there, they're going to give a red carpet and give you an emergency appointment. Unless you have an appointment, do not travel at all. Once you have an appointment, that's the right time. Remember that it's been 1.5 years. There's been a lot of restrictions on the so because the consulate is not fully operational. It also depends on how many restrictions have been put in the local country where they are located at. Sometimes they may even follow the local country's law on top of the release that we have right now. So we are not expecting the consulate to function fully, at least until the end of this year. There will be restrictive appointments, for those people who are eligible for the drop box. Also, there's a lot of restrictions that are there. So keep watching, keep clicking on it. You may get sometimes openings and you have to lock it at that time. Emily, on the budget reconciliation bill, seems that at least the Democrats came to an agreement at this point of time. What's in there for our immigration though?
Well, we're moving on to Plan C for the immigration portion, and at this point the Democrats seem to be limiting their requests to the Senate parliamentarian basically to the undocumented people. So Plan C is maybe paroling these individuals who are undocumented so they can temporarily stay legally for a 5-year period while they work something else out, because their prior path to citizenship was rejected and then the movement of the registry date was already rejected. So that proposal should be given, I believe the end of this week was kind of the target for that, and then it will take a few days to get her response. What happens after that, if she rejects it again? Some senators are saying they're willing to possibly forego her opinion and move forward without it, or I guess in the opposite direction and move forward with immigration reforms. At the same time, the big question is, what about employment-based? Are the reforms that were discussed in the House bill going to be provided in the Senate bill? Are those provisions being given to the parliamentarian? I think the answer is no, they're not being given to the parliamentarian, but that does not mean they don't intend to include them. There were some updates on Twitter today that they just don't want to provide too much to the parliamentarian all at once and muddy the waters. They need to get a clear answer on one proposal before they start talking about what their full proposal will be.
So be on the watchful, guys. There is a letter. There's a letter there we have provided for a draft to contact the senators and the congressmen to have the employment-based provisions to be included. Please use those letters. Keep writing those letters. Emily, Charlie seems that doesn't know the numbers, or does he know the numbers? Does he know how to calculate the numbers? Does he know how many number of the people of Indian country of birth, India, are backlogged? What's going on with on 23rd, the USCIS submits an affidavit. They're telling it's 12,000. This guy's telling a different number. What's going on in the EB3 here, particularly though?
Yeah, so I think everybody at this point is agreeing that in the pipeline, applicants already filed between 485 pending and applications at the Department of State. There are 80,000 employment-based third preference Indian nationals waiting. So these are applications that were already filed in the first quarter of last year, October, November, December, or that became documentarily qualified through the consular processing and are ready to receive the green cards. So we have 80,000. Magically, 80,000 went wasted. So it would have been nice had they used those 80,000. It would have completely cleared everybody who's pending and allowed new filings, but that hasn't happened. What's even worse is, for some reason, these, we've talked before that if the rest of the world does not use up all their allotment, which the allotment this year is double the normal amount, just like it was last year. So the EB3 gets a larger number, so rest of world has a huge number available. Charlie is saying, and this Andrew Parker is saying that they're only expecting a total of 12,000 green cards to go to EB3 India.
That is from the USCIS.
Yeah, that's from USCIS.
In an affidavit submitted in the district court, though. But when it comes to Charlie, though, they're telling a different story here. They're telling that there are 92,000 green cards that are pending, and there are only 80,000 that are available under the employment-based third category. But does Charlie know the processing times of the 485? Does he look into the processing times of the USCIS, which is somewhere between 14 months and 24 months? Does he look into that, or he doesn't consider that, Emily?
It doesn't seem to be considering that, because right now he should be moving the dates to accept applications for the following fiscal year 2023.
2023,
because USCIS is finally
going to adjudicate the
them.
application. He seems to be looking at the USCIS chart at all. He's only looking into the number of applications pending, but does he know that, hey, they're taking 24 months to approve the application? And let me also explain you, Emily, that the numbers that have been provided is that there are 92,000 applications that are pending right now in the EB3. Some of those things will not be adjudicated, though. They have issues, they have RFEs, some of them did not submit the medicals. They may not be coming in time, though. So they have to give approximately about 30 to 40,000 out. And then, as you said, that they need to look into not only this year, but next year also, and try to take the applications so that the applications can be processed. So definitely they are going in a path to waste the green cards again, as they did it last year. Last year, until about May of 2020, they kept on saying, we expect all the employment-based immigrations to be utilized by the USCIS. That's what they said. They said so many times. And come July or June or July, they started saying, oh, we expect some of the number of green cards to be wasted. And then he kept the number to go all the way to 100,000. And then because of the pressure from the congressmen, and the USCIS acted a little bit better than, as they did, though. And they were able to adjudicate a lot of applications in the last quarter, though. In fact, I checked, Emily, in the first three quarters, they adjudicated 75,000 green cards, while in the last quarter, they adjudicated 100,000 green cards in the employment-based. Thanks to all of our audiences who have written letters to the congressman, to the ombudsman, and to the USCIS, that did work. Instead of adjudicating 25 or 30,000, they did adjudicated 100,000. It's a good job, you did it, but not enough. We still need to do it. We want you to write letters to the congressmen or to the senators of your respective district and put a pressure on the USCIS so that we don't waste the green cards this year, just like the way we did it last year. The draft of the letter has been provided to you. You use this draft before it worked. We have that extra 75,000 that had been used. We want you to write the letters again. And we want these people to move the dates, though, to reflect the reality of what's going on with the USCIS. If they are taking 24 months, the inventory of the 485 that they have is not enough for the 24 months allocation though. They need to have sufficient. There's 290,000 green cards that are available this year. There are 140,000 that are available next year for sure. So we have approximately 430,000 green cards available. There are not enough number of applications pending there. They should move the dates right now so that wastage of the green card doesn't happen this year like the way it happened last year and will not happen next year. So we need to keep a pressure. If there are rest of the world applications are not there, they should give the green cards to the people who have been waiting. It is not whether Charlie is retiring, what is happening. We need to make sure that our thing is done. Maybe the other person will come in, we don't know. We want you to write letters to the congressman. We already seen 4 senators, Emily. Senator Cornyn from Texas, Senator Tillis from North Carolina, and 2 other senators, Rand Paul from Kentucky. These people wrote a letter. They're really mad on why they wasted the 80,000 green cards. I want everybody to write letters to the congressman. Even if you are not in the 485 application process, I still want you to write letter, because if the people who are in the pipeline, they get kicked out, you have a room to get in. If they are there, they are not going to they're not going to give you, priority dates are not going to move. If you look into the affidavit that is being submitted to the USCIS, to the District Court of Dallas, though, they clearly mentioned that USCIS is going to be in a loss if they allow people to file the 485 application. This is the affidavit that they submitted. They're going to be in a loss. Hey, buddy, it's not about loss. It's lives, it's families. It's the children that are aging out that is concerned. We are not, a little bit monetary loss is not a big deal. You want to charge for I-765, you want to charge for I-131, you go ahead and charge if you want to. It's not about money, it's about lives. Just because you're going to be lost, you don't want to move the priority dates, that is wrong. We are unable to get the courts accept our arguments. They're not even entertaining our things. They're saying that the courts don't have jurisdiction. So what is the way for us? The USCIS doesn't act, the State Department doesn't act, and the courts are saying, no, we don't want to entertain you. Now, we still have Congress, guys. We still have the Parliament. What we call here in the United States, the congressman. Please write letters to the congressman. The draft is provided. You can use the same thing to write to the ombudsman. These are the things that you need to do to move the dates, because USCIS is in Mars and the State Department is in Venus and we are on Earth. We need to bring them to Earth to have this. They wasted 80,000. We don't want to repeat the same thing again. Please keep writing letters. Anything else, Emily, before we move to the next topic? Emily, on the family-based versus employment-based, and especially, I say that especially the DACA kids, dreamers, I consider them as a family-based rather than employment-based. Why is that the Congress doesn't look into that these are the tax-paying people? These have been abiding by the rules, have been getting their visas, they have not violated their status, they don't have any criminal record. Why can't they give preference to these people, Emily?
Yeah, I think there are many members of Congress and the Senate that feel that employment-based immigration is pro-business, which it is, but for the benefit of business only. They don't take into account that green cards don't go to businesses, they go to people, and those people have families too. So whether you're in the family-based or the employment-based category, these green cards are going to families who are here legally and have been following all of the rules. They're not going to businesses. At the same time, when you talk about family-based immigration and then wanting to provide, new pathways for essential workers, well, guess what? Those essential workers work for businesses. So those businesses are going to benefit too, but nobody talks about that side of it. Everybody, anyone who receives a green card is going to benefit the individual as well as the employer. And so they should be treated exactly the same. There's no difference between those.
Let's go to questions. And before I go to questions, a lot of people are paranoid a little bit about their employment authorization document and advance parole. If the priority date backtracks, though, your EAD and advance parole will still be approved. I'm very shocked to know that a lot of people didn't know that. the EAD and advanced parole will still be approved. SNH from YouTube has this question. There is a little bit confusion of getting married to EB3. Explain it. There's a video that we have published last week, guys. It's about should you refile your application or should you do the interfiling? I want you to study. Practically marrying to EB3 is if you use an EAD. Other than the H-1B, you will be considered to have been married to EB3. Now, there are ways to get divorced and be single again. I mean, from the EB3 application is one, you can go outside the country, get the H1 or H4 stamping and come back. And one of the clever engineers suggested that, hey, can I go to Mexico and use automatic revalidation and come back on H4 and H1B? That's a good proposal. That's a good thing. I don't see that why it cannot be done. At the most, if they don't want to allow you on H1B, H4, they still will have to allow you on the advanced parole. You can try that one too. Questions from SP is asking 287% true. That guy is insane, Charlie. I don't know what happened. He used to be a very intelligent guy. I don't think so. He's trying to calculate. Guys, it's not 7% here. When there is no demand for other nations, though, it is not, there is no 7% rule. They have to give it to us. The 80,000 green cards that the stupid people wasted is our green cards. The people who are Indian and Chinese background, they are supposed to get it. They wasted. If there is enough demand for 290,000 green cards, then the 7% rule will come in. If not, there is no 7%. The rule changed in 2001. Before that, it was quite different. When the demand is there also, when there's rest of the world demand is there, they have to throw in the trash. That rule has been changed in 2001. If there is no demand, they have to give it to the country that is taking more than 7%. So it is definitely, and what happened to Emily is the statement he said, if it's documentarily qualified, we are going to count towards a number. That's what Charlie said. And everybody relied on the documentally qualified, I-140 approved, file the medical, final action date is current, but the number is not allocated. What happened?
Yeah, I think, Charlie, yes, he's from the Department of State. Department of State does use documentarily qualified when they're trying to determine who is ready to have their interview at the consulate. They look at dates for filing, and if your date for filing is current, they start processing the consular processing of the green card, and then once you're documentarily qualified, they will schedule for an interview. So they use that term all the time. That term doesn't exist in USCIS. So people saying, well, I filed my 485, I submitted my medical, my fingerprints are done, I responded to whatever RFE I had, now I should be considered documentarily qualified and I should have a visa number applied to my case. No, the USCIS does not operate that way.
And that's where we have put a video on titling that USCIS is from Mars and Department of State is Venus. I mean, they are not connected. The only way for us to get them connected is go to the congressman. Please keep writing letters.
Question from Surendra. Any news on H4 EAD premium processing? Is H4 EAD litigation working? So as far as premium processing, we don't have any updates on that. I think that current processing times need to get into a reasonable range before they're willing to implement premium processing. And I think H4 processing times are slowly improving. I'm starting to see some approvals that are coming in around the 5 to 6 month mark compared to the 12 to 18 month mark that it has been. It's definitely not that way across the board, but hit or miss, we are seeing some going through faster, which is unfair for the first in, first out people who did file 10, 12 months ago and are still pending. As far as litigation, we do still have the H4 and EAD class action lawsuit going on, as well as an L2 EAD class action lawsuit. And there are things happening with both of those. We can't comment on them at this point, but we're seeing progress and hope to have some good news on that front soon.
Can the interfiling or refiling be done based on the filing dates? Sweet Swiller from YouTube. You can definitely do the refiling though, if the filing dates are there. Can you do interfiling when the filing dates are current but not finalized? You can, but I strongly recommend you do not. Because what are you requesting when you're doing an interfiling? You're telling them, adjudicate your 485 application. But if your final action date is not current, that doesn't work. So I would wait. I will not do interfiling unless the final action date is current. Now, people are asking whether the EB3 is expected to move based on legally it's supposed to move, logically it's supposed to move. If you look into the numbers, if they didn't waste it 80,000 and they don't plan to waste any of the green cards this year, it's supposed to move, but they are not in this world. They are in Mars, so they didn't move. And according to Charlie's statement today, EB3 may move backward and EB2 may move forward. Now, there are a lot of people who are speculating with regards to how the date movements will happen. There is a lot of other immigration lawyers that are pointing out, and Charlie is also pointing out how the dates will move. And let me tell you guys, I was an immigrant before I became an immigration lawyer. That is my first qualification as an immigration lawyer. That is what I always said. I have gone through the process of it. Most of the people who are in EB3 also have an I-140 approval in EB2. Most, I would say at least 80% of the people, Emily, that are in EB3 right now, that have filed the adjustment of status for India, are also have an EB2 approval. Now, so what will happen is that when the dates for EB2 will move, a lot of these people, either they will do interfiling or they will refile it and join the line of EB2. Then what will happen to EB2? It's going to backlog again. Then what happens? Then people will do the interfiling because most of them have EB3 approvals also. They will move back to the EB3 line. And this back and forth of the line movement will happen. It will be, if anybody has not driven in Los Angeles, so that's the worst place to drive. The lane I go always doesn't move. The lane next to me moves. Guess what? When I move to the next lane, that doesn't move. It just happens with me for whatever reason. I don't know why. Now, the same thing will happen with EB2 and EB3. If you look into the Chinese national, so that's what's been happening from past 10 years. Sometimes EB2 moves, sometimes EB3 moves, sometimes EB3. That happens. So that's the reason why we put a video last week with regards to interfiling and refiling, which one is better. Now, we are not telling you which one is better clearly to you, but you can make an informed decision watching that video. So my projection is that the EB2 and EB3 will keep going forward and backward. That's going to happen continuously. If the USCIS and Department of State works prudently though, and if our congressmen work better and getting all these applications of things, all things should move forward though. We have already seen 4 senators acting. They have written an open letter to the USCIS criticizing and also asking the information why the delay is happening, which is a good move, but we still want more pressure built from the Congress to get these things rectified.
Urshad asks, if my company relocates me to another country for 1 year and in a managerial position, will I become eligible for EB1C upon return? Possibly, but not necessarily. So there are several qualifying factors for EB1C. Number one, there has to be the correct qualifying relationship between the U.S. company and the company abroad. The position abroad had to meet the exact definition of manager. So just because it's called a manager doesn't necessarily mean USCIS agrees it's a manager. You also have to be offered a U.S. position that is manager, that meets that same definition. So not every manager meets the definition of EB1C manager. So just because you've spent 1 year outside the U.S. as a manager does not automatically mean you're eligible for EB1C.
Raju Kandam from Facebook has this question. If he uses the 485 EAD and his wife did not receive the 485 EAD, now this happens very frequently recently, can his wife continue using the H4 EAD? Unfortunately not. Once you are married to the adjustment of status, you are not an H1B. Since you're not an H1B, your wife is not an H4. Since she's not an H4, she cannot work on H4 EAD. You either file a H-1B and then move to the company, or you wait until your wife's H-4 EAD comes, or the third option is she should stop working on H-4 EAD once you start working on EAD.
Raul from YouTube was lucky enough to have an expedite request for an I-539 change of status approved, but then nothing has happened for the past month. Is there any other way to expedite the processing and get a decision? Well, our definition of expedite and the USCIS definition of expedite are completely different things. I see time and again when people get an expedite approved and it takes 2-3 months for the process to actually be completed. So 1 month is normal, unfortunately. Their version of expedited processing can be several months.
Can you explain 280,000 green cards available, yet EB3 is only January 2012? I cannot. These are people from Mars and Venus. I don't know how to communicate with them. We tried, we wrote the letters to them, and they put a note saying that no more letters from earthly people. Really, they put it. They put it against us. So they don't want to answer our questions properly. They don't want to address our questions properly. You are right. If the 280 or 290,000 green card, it should not be January 2012. It should be somewhere even in January 1st of 2015. That should be the way, but it's not.
Soham says, how risky is it for someone to do H-1B stamping from Canada if appointments are available? I already have the DS-160 and submitted fees. Is it transferable to another embassy like Canada? Well, Canada and Mexico are really not processing third country nationals. They're still limiting their services only to their own citizens and really still only for emergency situations. None of the consulates are operating fully, and I don't expect that to change anytime soon, so it's very unlikely that you would be able to get an appointment.
Harry has a birth certificate only with his first name, not the last name. Parent's name has a last name. The birth certificate will be fine for filing the EB3 green card. It should be fine. You may alternatively get affidavits and some other documents. I've listed that in our website, rnlawgroup.com. You can check the birth affidavit. There are other documents. Get them, don't submit to them. File with what you have. If they ever get to the RFE, at that point of time, I want you to provide those documents, which are alternative documents in birth certificate.
Sweet Seller says, can interfiling or refiling be done based on filing dates? Refiling can be done based on filing dates, assuming that USCIS allows us to use the filing dates in a particular month, like they are in November, and you've continued to maintain your non-immigrant status. Interfiling, the only reason to interfile to a different category is if the final action date is current. If the filing date is current, you're basically retrogressed in both categories. So it doesn't really do you any good to interfile into a different category when that date is not current either.
Aditi Gupta from Facebook has this question. What are your insights? How early in the year can the USCIS use the spillover? If they only use it in the last quarter and they can't use it because of the resources, they can't use it in the last quarter, it's meaningless to have this spillover. Makes sense what you're speaking. Definitely we need to put a pressure. Last time, Aditi, we put a lot of pressure on the USCIS, which worked to an extent, because instead of adjudicating 25 or 35,000, they did adjudicate 100,000 green cards in the last quarter. If we keep putting the pressure, though, they should be able to adjudicate the 290,000. We should try our best. There is no law that says that the other than 7%, the spillovers can only be used in the fourth quarter. There is nothing in there. The State Department, with their intelligence, they can estimate the rest of the world demand. They can estimate, yeah, they can leave a little bit room for the rest of the world to come in. But hey, the inventory tells you how many rest of the world people are there. And unlike the family immigration, not many employment immigration goes to the consulate. So it is very based on the data that you have, how many number of applications from the rest of the world are there. You should be able to estimate it very clearly. There's no reason for us to wait until the fourth quarter. But how do we make the USCIS, and especially the State Department? The State Department seemed to be the culprit here because the USCIS did acted 100,000 green cards in the last quarter. If the State Department does not move the dates, this USCIS cannot approve it. So we may have to keep a lot of pressure on the State Department, keep writing letters to the congressman. That's all we can do right now.
Narayan says, did we see any movement for age-out kids in any bill? So we do have a few bills that provide relief for age-out kids, but right now all eyes are on reconciliation, and nobody's talking about these separate bills for age-out kids. So those would likely only move forward after this whole reconciliation process is done, and depending on what gets included in reconciliation.
Asha Sheikh has got the biometrics done 2 weeks back, interfiled medicals. Are they trashing the medicals or what's going on? There are a lot of people who got the green cards when the final action dates were being current that have filed the interfiled medicals, but did all the medicals went to the file? As of now, the report seems to be that almost all. Asha, I would suggest you that you can go to FOIA USCIS, file a freedom of information on your 485 application. You will come to know whether your medical has been incorporated into your 485 file. This is an easy way. You can do it. It takes only 10 minutes. It takes 3 weeks for the USCIS to respond. FOIA USCIS. This is an easy way. You don't have to go through the bureaucratic system. Just file for a copy of the 485. You will get the information.
Hari Heron says, can I leave the company while the I-765 is in process? I'm assuming this is based on a pending 485. So number one, do you qualify for AC-21? Because you want to make sure that your green card process can go with you to that new employer. That means that your 485 has to be pending for at least 180 days. Your I-140 is approved, and the new job that you're moving to is in the same or similar occupational category. On top of that, if you don't have the EAD, that means that you have to do an H-1B transfer in order to start working for that new employer. So there's no problem with that if you don't have the EAD, but the new employer has to be willing to do that H-1B transfer and get it approved.
Mayank Agarwal, if my wife uses the GCEAD, do I lose the H-1B? No, you won't lose the H-1B status. She will lose the H-4 status. She is married to the GCEAD, but you have the H-1B status. And then when she gets her H-4 and H-4 EAD approval, though, there are ways people are doing it. I mean, this is you can always go to Mexico and come back on H-4, and then H-4 will be active. Nothing wrong with it. So there is easy hacks you can do. We call it as hack. You just go to Mexico, and you may ask a question, Mac. She doesn't have the H-4 stamping. How can she go to Mexico and come back? It's called automatic revalidation. If she's only visiting Mexico for less than 30 days and she's coming back, she doesn't need a visa to come back. She can use the H-4 I-94 that she gets an approval. Most probably you already filed for the H-4. It still is pending there. So once that approval comes in, she can go to Mexico and switch back to H-4.
Leah asks, how about extensions of advanced parole and EAD if your date isn't current? Will there be delays to extension processing times? Unfortunately, yes, right now we are seeing that. You know, when you file that EAD and AP renewal, the EAD is auto extended for 180 days, but we've come across a few cases lately where 180 days wasn't enough time, even if you filed at the very first opportunity when you can file for that renewal. So hopefully these things will get better as the COVID situation improves and USCIS works on its efficiencies. But yes, that is becoming a problem now.
Vivek has this question. Is it safe to change jobs on 485 EAD in the same profession? Some lawyers recommend not to change a job on EAD. Well, these are the lawyers who buys Ferraris, guys. These are the lawyers who buys designer clothes. You know, we are not that rich. My personal thing, if I were in adjustment of status, I'm going to use the EAD. I'm going to let the H1 out. In fact, Vivek, I was on H4 at the time when I got an EAD, an adjustment of status. I let my H4 go and I used EAD. On EAD, in fact, I was an immigration lawyer going to the 485 interviews on adjustment of status EAD. This is my personal. When I, on being an immigration lawyer, being an EAD, let my status go and use the EAD, what can I tell you? You should get the idea what you should do. Now, why do lawyers scare people? Some lawyers, no, I wouldn't say that all the lawyers, that some lawyers, and these people will become more famous because they scare you a lot more. Why do they do it? Well, they want to buy Ferraris on your name, and that's the reason why they're doing it. So if I were you, I would use the EAD. Are there some pluses and minuses on using the EAD? I think so. We're going to make a separate video for it. What are the pluses? There definitely are some advantages of maintaining the H-1B. There are some advantages of using only EAD. But what we see is that there are more advantages on EAD than that of the H-1B, because every time you go outside the country, you have to get the stamping, you have to file an amendment. H-4 EAD is a big trouble for you. All those things can be eliminated if you just use the EAD. So there are advantages that's the main advantage of EAD. Question, Abdul Imran, if I refile EB2 and I get the receipt notice, can I use the EAD for EB3 485? You may be technically considered to have been married to EB3. If your intention, Abdul, is to refile the EB2 though, you should not be using the EAD and advance parole. The better way for you would be, Abdul, at that point of time, is instead of refiling, is actually doing the interfiling. In that way, then you're fine. You should not have been any trouble in using the EAD.
Lots of questions about, downgrading in October and should I move back to EB2? I think that, as Rahul explained earlier, these dates move back and forth. We expect to see some flip-flop. When you move into one lane, that lane slows down and the other lane that you were just in speeds up, and then you move back into that faster lane and it immediately slows down. So I think for a lot of people, there's really no right or wrong answer. I do think having multiple options is always a good thing, because that way, whichever one happens to get ready to be approved and the final action date current first, they can approve that one and you withdraw the other one. But should you do it? It's really just a personal judgment call if you feel that having kind of 2 eggs versus 1 in the basket is going to provide you any potential benefit.
Prashant has this question. She's on H-1B, her spouse is on H-1B. Can I file 485 along with my husband's 485 application even though I am not on his dependent visa? Absolutely, you can. All you need is you are happily married with him, and that's all you need. You can be an H-1, you can be other visas. That's perfectly all right.
Subject said, my daughter got an EAD and will be aging out next year. USCIS mentioned she will get the GC when I get it. Is that correct? So if your I-140 was approved and your final action date became current and your child's age was under 21 at that point, then your child's age is locked in even if the dates retrogress in November. So yes, if that is the case, because she filed the 485 with you, when you get your green card, she will get hers even if she ages out while that happens, if she actually turns 21.
Thanks for correcting. Love to Learn is giving that. It's not 80,000 that's wasted, it's 62. Thank you for correcting. That's right, it's 62,000 that's been wasted, but still 62,000 is a lot. Let's hope so next time we will not waste anything. This time we have more numbers, so more to be adjudicated this year.
Anil got an RFE on the 765 but never received a copy. Contacted multiple times, opened multiple service requests, no response. It's been 3 months. What can I do? We do see this from time to time. Number one, I would request case assistance to the USCIS Ombudsman Office. That's the DHS 7001 form. I've used that for some of my AOS cases where we never got the RFE for the medical exam, and we were able to get it and submit the response for that. You also can try my USCIS account and try chatting with Emma to see if they can email it to you or upload it into your account.
I may suggest one other thing, Emily. File one more EAD. File one more EAD. The filing fees is free. Go ahead, file one more EAD. It won't harm you, definitely, for sure. What is your opinion about filing litigation for EAD? We are not accepting H4 EAD delay litigations, guys, but we are accepting the EAD delays for 485 application. There's a very good article published by Stephen Brown today on rnlawgroup.com. I will try to give the link later on, though. You can go and contact Stephen Brown. He would be the right person if you are trying to litigate based on the EAD delays. Stephen Brown, not Emily, not me, Stephen Brown in our office.
Prashanti is on H-1B and her spouse is on, oh, okay.
One second.
DT says, does an L1B need to resign from the current employer if they get an H4 approval, or can they go on leave and join after getting an H4 EAD? So it sounds like you were on L1B and then got a change of status to H4 approved without getting the EAD. That means you're not eligible to keep working for that company. Whether the company lets you go on some sort of unpaid leave or terminates is going to be a company decision.
Cool dude, my grad date is January 31st, 2012. Moved to EB3. Now should I move back to EB2? Wow, that's a tough question. I want you to watch watch the video. We put it on last week with regards to interfiling and also refiling the application. You may want to watch the 10-minute video that we put it on last week.
A question, what are the chances that my application goes to the National Benefit Center if I refile an EB2 straight application? So, knock on wood, we've been seeing standalone 485s where the I-140 is already approved. Even if you file at one of the 3 lockboxes based on your address, they are generally going to the National Benefit Center. Hopefully that will continue. That has been our experience, and they do seem to have much better processing time for both the 485 and the EAD AP.
Vishnu submitted AOS in September 2021, got a receipt numbers with MSC 22 instead of MSC 21. How can we fix it? Yeah, if the application has been, even though it's been received in September 2021, sometimes they open it in October. That's when the receipt notice has been issued. We have noticed that they will put 22 there if it's open on 22. It's not, it won't affect your processing or anything. I would not be worried about it. I would not like to correct that one.
Ilongo, what is the current timeline for H4 and H4 EAD approval? Is there a chance for premium processing? Is it good to go to India, get the H4 stamp, and then apply for the EAD once back? Current processing time, according to the actual processing times that are posted for the different service centers, are around 9 to 11 months last time I checked, so still not great. And that's regardless of whether it's premium processing of the H-1B or not. We're not seeing premium processing availability yet. They're not really talking about that. I think they need to get the regular processing timeline under 6 months before they're planning to go forward with that. Is it a good idea to go get the stamp and then apply for the EAD once you get back? The EAD standalone may be slightly faster. So it does depend on whether you can get the stamp, whether you can get an appointment, or whether you can do the drop box, because visa stamping is quite a mess right now. Even if the travel ban goes away, consulates are still not operating fully. But if you can easily and quickly get the stamp and come back and then file the EAD, that is a good option.
Is there a chance that the rest of the world EB3 retrogress in 2022? Very, very, very rare chance, Rohit. Very, very, rest of the world, very, very rare chance. Because we have a lot more numbers available this year than that of any previous year under EB3.
Hawaiian Island says, how long is the employment-based 485 interview usually, and what are the most common questions asked? I think the amount of time of the interview, assuming it is a straightforward case, no issues, no criminal background or anything like that, the actual interview time is maybe 15 minutes. You'll probably spend more time getting into the building and waiting in the waiting room than you will actually during the interview itself. As far as the most common questions asked, I think we did a special
10-minute
video on that. If you go to our YouTube page, you'll find that special topic, AOS interviews, do's and don'ts. But they do ask a lot of the questions that are asked on the 485 application form. So definitely review your 485 form before you go to that interview.
Sai Abraham asked this question: why USCIS asked the maintenance of status RFE from F1 OPT to H1B? Sai, before they give you a H1B status, it is their duty to make sure that you are maintaining the legal status. Just because you're on F1 doesn't mean that you're maintaining the status. For you to be maintaining status on OPT, you have to be working or getting trained in questions whether you're getting paid for that period of time, especially if you're in STEM extension, you're supposed to get paid for that period of time. So maintenance of status is an absolute necessary for them to see to grant a H1B. They can grant a counsel processing, but if they have to grant the change of status, it's their duty to make sure that you are in legal status.
Mitu has a friend who applied for an OPT and got a rejection due to some issues. She made all those corrections and then resubmitted the OPT application, but resubmitted the old I-20 rather than getting a new one. Is it a problem? Will the application be denied? So the I-20 that's issued from the school has to be valid at the time of filing the OPT application. In this case, the time of filing is the refiled application. So if that has expired, yes, that application can be denied. So if you are still within the window to be eligible to file your OPT, you may want to talk to your school about getting a new I-20 and sending another OPT application to avoid having that first one denied, because that denial might take 6 months to come, and by that point, you're out of the window to file. So yes, you should take action immediately on that.
Sweet Seller is asking whether in the previous video is refiling better than interfiling. Is that a true statement? No, I would not agree with that statement. There are some pluses for refiling. There are some pluses for interfiling. So it's not a clear-cut statement from our video that that refiling is better than interfiling. No, it is not. It is not a clear-cut statement. There are some places for here, some places for the interfiling.
Hitesh asks, is there any way to expedite the PERM process? Can I contact my congressman? No, I've never seen a PERM expedited, even when people were maxing out of their 6-year limit, when premium processing was not available for I-140s. They do not expedite a PERM for any reason. It's always first in, first out.
How often EB1 to EB2 spillover happen? Is it monthly, quarterly? How does the rest of the world, the most retrogress country? A good question though. It is an internal information that is between the State Department and the USCIS. We did file a freedom of information. They're taking a long time to respond to that thing. But it's an internal communication between the USCIS and the State Department. Yes, very many times there will be a spillover from EB1 to EB2, especially so in this year though, there for sure will be expected to have a spillover from EB1 to EB2. We may not be expecting that much spillover there may not be a much spillover from EB2 to EB3 because there are a number of applicants are there in EB2, but there is an expectancy their spillover will be a lot this year compared to the preceding 3-4 years. So we do expect spillover. So the numbers that have been allocated from EB2 will be increased when the spillover comes from the EB1 to EB2. Now, with regards to the rest of the world, the State Department is supposed to look into the demand in the previous years, should be able to estimate it, and they should leave a little bit room in the final quarter to adjust though. A little bit room, but they should not be having such a big room where they will waste the entire green cards, because the documentary qualified word does not exist in USCIS as what Charlie imagines. It's a word that he invented. I don't know where he came from. That does not exist in USCIS. So he should have an estimate. Look how much time it's taking for the USCIS to process. According to the online, anywhere between 14 months to 18 months. But does he move the dates accordingly? No, he's not. That's the reason why he wasted 80,000 green cards last year. So we have to make sure that he doesn't waste, sorry, not 80,000, 62,000. But we have to make sure that he doesn't waste the green cards this year.
Sagnet, his USPS lost the EAD in the mail, even though it was tracked to his mailbox. Nobody can find it. Submitted an e-request. What else can I do other than filing the I-765 again? And what happens to the AP? I would file it again. You are going to waste so much time and effort, and at the end of it all, they're going to say, because USPS did not return the EAD card back to us, there's nothing we can do. That's been my experience. Just file it again, file the AP again as well, assuming that it was an EID AP combo card, just refile.
Sudhakar Patra has that if the House budget bill passes, the same version, Senate also passes, there will be a flood of applications. I'll start celebrating Diwali as soon as they pass both the things in the bill. Yes, definitely. The House bill has a good provisions, especially for the employment-based. Even if the priority date is, if you have an I-140 approval for 2 years, I mean, you can file a 485 application. There are a lot of provisions in there that are really my dream provisions there. I wish they would be incorporated into the Senate. I wish they have been passed. This is the right time, Mr. Patra, for you to write a letter. We have given a draft of that. At the bottom of it, keep writing, especially to the senators, because we know that in the House we are going to be fine. We need that one to be passed in the Senate. So please keep writing. We need the House version to be incorporated into the Senate, especially the immigration provisions.
Anoop has a really important question for people who are considering refiling. He says, if I refile the 485 and EB2, what happens to my son's age that was frozen when my EB3 was current? So because your son's age was frozen in the EB3 does not mean it will be frozen in the EB2. When you refile the EB2, they're going to look at how long your EB2 I-140 was pending, subtract that from the age at the time your EB2 final action date becomes current. Only if his age, the calculated age, is under 21 at that point will his age be locked in under your EB2 case. So you may have to consider sticking with EB3 where his age was locked in so he doesn't miss the boat.
Yeah, be very careful, guys, especially if the age-out kids are there. It may not be advisable for you. If the kid's age is already locked in, you may not want to file an EB2. And the danger is that if you get the green card in EB2, and that's more dangerous, actually. So definitely, before you even contemplate on refiling, if you have an age-out kid who's already locked in, you better have a consultation with the lawyer before you file a 485.
Sujanya says, what can be the maximum number of days for USCIS to send a response back about a 485 when the priority date is current, medical RFE response was submitted over 60 days ago? There is no maximum time. They can take as long as they want, and even courts are not going to step in and try to tell them they have to hurry up and adjudicate it, even though your priority date is current, your medical is submitted, all your security checks are done. They can take their sweet time, unfortunately. The only thing you can do is if the processing time is beyond the normal processing time, according to the ridiculous processing times on the USCIS website, you can then put in a service request. But other than that, they can take their sweet time.
MBSN Raju has this question. My friend got the prior date is January 2013. He got an RFE, so if he responds to the RFE within the end of this month, if they receive it, is his number locked? Unfortunately not. That is not. I have a good suggestion from Harry Caps. Hey, can I become a Canadian citizen and can I stand in the line of the EB2 of Canada because now I'm a Canadian citizen? Unfortunately not. If that were true, I would have got all my Indian citizenship, some other citizenship, by paying $10,000 or $5,000. They can get a citizenship in some countries. I'm not speaking illegal. There are some countries. You pay them $5,000 or $10,000, they'll give you citizenship. It's so easy. For the purpose of the green card, it is the country of birth and the citizenship at which you have been holding that controls, though. So even if you change the passport to a different country legally, you will still be considered as an Indian national. Now, one exception though is that, let's say for example, if a person is born in Saudi Arabia or UAE, the Dubai, okay, can that the person will not be given citizenship. We know that is right. I mean, the Indian guys, they have children there. They still will not be considered to be. They still will be holding the Indian passport. They will be considered as. They will be considered as if that they are the citizens of the Saudi Arabia or UAE for the purpose of the green card application. So please make a note. The other exception that's available is that if one of the spouse, if the spouse is from a different country, let's say for example, the guy is Indian and the lady is a Chinese national, or let's say lady is a Malaysian national, then what happens is that it's called cross-country chargeability. You will be coming under the Malaysian quota even though you're not born in Malaysia. In the same scenario, you are born in India and your wife is born in United Arab Emirates. Even though she holds the Indian citizenship from the beginning, though, it still will be considered as cross-country chargeability. You'll be charged, you and your wife will be charged to UAE's account, not Indian account, which is actually very good. So if any of you have those exceptions, you may want to read an article that I've written on cross-country chargeability in RN Law Group's website.
Time for one last question. We'll take this one from Sheetal. Her premium processing I-140 was just accepted on October 20th, so the 15-day clock will be November 3rd, which is when retrogression will happen, November 1st. Is there a way we can request premium processing to adjudicate it by the end of the month to lock in the child's age? That's a great idea. I would do it. Now note that only your employer or their attorney can do it. You personally cannot do it, but yes, make that request. It is not going to hurt anything. They might do it. There's no guarantees, but definitely give it a try because that's really
very
important.
crucial though. Yeah, because you need to lock your child's age. I would contact the congressman. I would contact the USCIS. I'll send an email to the USCIS. They may do that. Those are the kind of things sometimes we see they do it. You should make an attempt.
All right, well, we're out of time for today. Thank you so much for joining us. We'll be back next week, and go Astros.
Thank you.